So, ang work stoppage ay hindi tumatagal ng hindi bababa sa teorya hanggang hindi na aayos ang hindi pagkakasunduan o inuutos ng proper authority. Ang action ay concerted kapag ito ay isinagawa ng group of person acting in unison para sa isang purpose o para sa kanilang common goal. In its legal context, ang grupo na tinutukoy dito ay yung legitimate labor organization na binubuo ng empleyado ng employer kung saan sila ay mayroong hindi pagkakasunduan. Ang pagpapatigil sa trabaho ay dapat resulta ng industrial or labor dispute. Ang labor dispute under Article 219 includes any controversy or yung mga issue or matters concerning terms and conditions of employment o association o kaya naman ay representasyon ng isang tao sa negotiating, fixing, maintaining, changing, or pagsasaayos ng terms and conditions of employment regardless whether the disputant stand in the proximate relation of employer and employee. Ang labor dispute para maging valid cause ng strike ay dapat one between the employees represented by a legitimate labor organization and their employee. And ang intra-union or inter-union dispute, kahit na yun ay labor dispute, ay hindi ground for a strike. Dapat ito ay ma-pointed out, subalit ang term na strike ay hindi lamang tungkol sa pagtigil sa pagtatrabaho, kundi pati na rin sa slow down, mass leave, sit down, at yung mga pagtatangka na masira o sirain o isabotahe ang mga plant equipment and facilities at yung mga similar activities. Ang lockout, hindi siya concerted action kasi as a rule, ang employer ay mag-isa lamang kumikilos kapag nag-declare ng lockout. Ang lockout ay temporary stoppage of work din, pero ito ay hindi sinasagawa sa pamamagitan ng voluntary withdrawal from work by the employees, but by the employer refusing to provide work for them. Kasi diba ang employer siya ang nagpo-provide ng work para sa mga employee. Dito sa lockout, nire-refuse ng employer na mag-provide ng work para sa kanyang mga empleyado. Gaya ng strike, ang lockout ay resulta din ng labor dispute sa pagitan ng employer at employees. Pangatlo, i-discuss naman natin yung mga provisions common to strike and lockout. Strike and lockout share common requirements for their validity as well as common recourses on the part of the proper authority dealing with them. Strike and lockout may be declared only on two grounds. Yun ay ang ULP or unfair labor practice at ang CBD or collective bargaining deadlock. As stated earlier, ipinagbabawal sa batas ang strike o lockout sa pagitan ng inter-union or ng intra-union dahil ang ganitong klase ng controversy ay hindi sa employer. Ang ULP strike o lockout ay dala ng tungkol sa unfair labor practice committed by the employer or the labor organization as the case may be. Ang economic strike caused by deadlock in collective bargaining is one held para puwersahin ang sweldo o ang iba pang economic concession o yung mga privilege ng empleyado sa kanilang employer, which the latter is not required by law to grant. Ang deadlock ay maaari ding umantong sa pagde-declare ng employer ng lockout. Ang notice ng strike o lockout in prescribed form ay dapat nakafiled sa DOL, specifically sa wastong regional branch ng NCMB ng at least 30 days bago ang intended date ng kaso ng collective deadlock or at least 15 days from the intended date thereof in the case of ULP. Ang kopya ng nasabing notice ay kailangang iserve on the other party concerned. Ang cooling off ay dapat maobserbahan ng partido sa panahon ng applicable notice period at ang NCMB ay dapat mag-exert ng effort to effect settlement between them sa pagitan ng conciliation and mediation. Ang partido ay under obligation to participate fully and promptly sa conciliation meeting na ipinatawag ng NCMB. Gayunpaman, sa kaso ng dismissal of employment of duly elected union officers, which may constitute union busting na kung saan ang existence ng union ay pinagbabantaan, ang 15-day cooling off period sa ULP strike ay hindi i-apply at ang union ay maaaring magsagawa ng aksyon immediately. Ibig sabihin, under the Omnibus Rule, ang union ay maaaring magdeklara ng strike immediately pagkatapos na magsagawa ng strike vote at ang result ay maisubmit sa wastong regional branch ng NCMB. Consequently, ang union ay maaaring i-disregard hindi lamang yung 15-day cooling off period pero pati na rin yung 7-day period that is required to elapse from the date of submission of strike vote result bago magsagawa ng strike. Sa ganitong sitwasyon, ang union ay pinahihintulutan na magsagawa ng aksyon immediately. Ibig sabihin, ang union ay pwedeng magdeklara ng strike without waiting for the lapse of the said period. Because its survival as an organization is at stake. If the rule were otherwise, the strike could turn out to be a futile exercise. Sa panahon ng paglilitis sa conciliation, ipinagbabawal ang mga partido na magsagawa ng anumang kilos na maaaring makahadlang o makagambala sa early settlement of dispute. The said proceedings, however, do not operate to render an employer's previous order to its employees in connection with their work illegal or unenforceable, so as to excuse continued non-compliance therewith. The employer may appropriately penalize such defiance, to the extent of dismissing the erring employees. Ang decision to strike ay dapat approve ng majority ng lahat ng member ng union sa collective bargaining unit concerned, obtained by secret ballot in a meeting o kaya naman ay ng referendum called for the purpose. On the other hand, ang decision to declare a lockout ay dapat approve ng majority ng board of directors ng corporation or association or ng partners kung partnership, obtained by secret ballot in a meeting for a purpose. The decision is valid for the duration of the dispute based on substantially the same grounds considered when the strike or lockout vote was taken. Yun lang po ang report ko. Maraming salamat.